Hello everyone and welcome back to Nyay Patsala. Today we have an interesting and informative topic to discuss in the field of criminal law. We will be looking into the difference between suspension of sentence and suspension of conviction. Whenever we argue a criminal appeal before the division bench or the single judge of the High Court or in the Supreme Court, we are so tense at that moment. If we get an order of suspension of sentence, we are happy. Because once we get the suspension of sentence, we know that bail would be granted. But we must know the difference between suspension of sentence and suspension of conviction. Because in case of a government servant or a public representative like MLA or MP, suspension of sentence will not allow the government servant to rejoin the duties after his conviction, and similarly suspension of sentence may not allow the public representative to join the assembly or the parliament. So it's very important we know the distinction between suspension of sentence and suspension of conviction in criminal law. As the trial starts, an accused is either convicted or acquitted at the conclusion of the trial. In case if he is acquitted, that is the end of the matter. And unless an appeal is preferred against the acquittal by the victim or the state. In case if the accused is convicted, then judgment of conviction is followed by an order on sentence, and accordingly the accused is convicted and sentenced. And if the convicted person decides to file an appeal against his or her conviction, then section 389(1) of the Code of Criminal Procedure comes into play. So let us understand the text of section 389(1) in the Code of Criminal Procedure 1973. The section 389(1) in the CRPC starts with like, if any appeal is pending of a convicted person, the appellate court may, for reasons to be recorded by it in writing, order that the execution of the sentence, kindly pause here for a moment. 389(1) talks about execution of the sentence and not about suspension of the sentence. We'll explain later on. And it says order that the execution of the sentence or order appealed against be suspended. And also if he is in confinement, then he may be released on bail or on his own bond. The importance of this section 389(1) CRPC is that it allows an appellate court to temporarily postpone the execution of the sentence and release the appellant on bail. Because if you suspend the sentence and you don't release the accused or the appellant on bail, then they will still be in confinement during the appeal process, which essentially means that the convicted person does not have to serve their sentence right away when we talk about suspension of sentence, and the sentence is put on hold until the appeal against the conviction is resolved. So let us understand this suspension of the sentence a little more in detail. Suspension conveys postponement or temporarily preventing a state of affairs from continuing. And what is the purpose of postponement of sentence? The purpose of postponement of sentence cannot be achieved by detaining the convict in jail. So whenever a sentence is suspended, as a natural consequence of postponement of execution, the convict is always entered and enlarged on bail until further orders. We all know the principle underlying the theory of criminal jurisprudence in our country is that an accused is presumed to be innocent till he is held guilty by a court of the competent jurisdiction. But remember, Once the accused is held guilty by any court of law in India, the presumption of innocence gets erased. This presumption of innocence will no longer hold. In the same manner, if the accused is acquitted, then the presumption of innocence gets further fortified. So, suspension of sentence I have explained to you. Now let us understand what is suspension of conviction. In the Code of Criminal Procedure, suspension of conviction is not explicitly mentioned, and it also does not prohibit such suspension. So, what is suspension of conviction? Suspension of conviction goes beyond just suspending the sentence. It puts the entire conviction order on hold. So, in practical term, this means that the convicted person won't face any other consequence of the conviction until the appeal is finally decided. And remember, this is significant because it can help erase the stigma attached to the conviction. To better understand these concepts, let us look at some of the legal cases and court decisions. For instance, in the case of Rama Narayan versus Ramesh Narayan, reported in 1995 to SCC 513, the Supreme Court emphasized that if a conviction leads to disqualification, the court can grant the order of suspension of conviction when necessary. However, it's important to note that the suspension of conviction is not the norm. It is considered an exception and is granted in rare cases, depending on the circumstances and consequences of the conviction. The Supreme Court has consistently emphasized that this power of suspension of conviction should be exercised cautiously and only when the applicant or the accused demonstrates adverse circumstances or disqualification that may result if the conviction isn't suspended, then a suspension of conviction is ordered. But remember the key points in one of the judgment of the Honorable Supreme Court, that is State of Maharashtra versus Balakrishna Dattaraya Kumbha, reported in 2021-12 SCC 384. In these cases, the Supreme Court has emphasized that in cases involving corruption charges, courts are generally less inclined to grant the relief of suspension of conviction. And this has been reiterated in Union of India versus Athar Singh, reported in 2003-12 SCC 434 and 2001-6 SCC 584, that is KC Saxena versus CBI Chandigarh. So to bring this all into context, that is suspension of sentence, suspension of conviction, you should look into a recent case in the case of Sanjay Singh Patil versus State of Maharashtra. It was a case of the Bombay High Court. You would kindly look into it in the SCC online, where the court in this case has granted the suspension of conviction to an individual convicted under section 498 of IPC because the appeal had been pending for years and the conviction was causing great hardship to the accused appellant. And this is a case which illustrates how suspension of conviction can be granted when circumstances warrants it. The other case is Om Prakash Shahani versus Janishankar Chaudhary, reported in 2023 6 SCC 123, and the 11th paragraph is paragraph 33. In this case, the Supreme Court highlighted that for a court to suspend the substantive order of sentence under section 389, the accused appellant should show that there should be something apparent or gross on the face of the record. In simpler terms, there must be a clear indication that the conviction may not be sustainable. Therefore, the court's endeavor is always to determine if the prosecution case as accepted by the trial court in which the convict has fair chances of acquittal. If there is no fair chance of acquittal, the court can consider even suspension of conviction. And the appellant court while considering suspension of conviction, should not reappreciate the evidence at this stage of suspension of the conviction or suspension of the sentence, and just not try to pick up some lacunas or loopholes here and there in the judgment of the case from the prosecution side of view. And the Supreme Court has held that this is not a correct approach. So today we have explored the difference between suspension of sentence and suspension of conviction in the context of criminal law. Kindly remember, these legal concepts are not applied uniformly, and each case is evaluated on its own merits. So let me pause here and summarize. So suspension of sentence will not automatically entitle to suspension of conviction. Suspension of conviction is ordered if there is a chance of disqualification, if there is a chance of causing adverse harm to the accused appellant, that he is a government servant, he will not be reinstated in service, he can be terminated from the service. And in all those cases, the court has to see that there are chances of acquittal. And it should not discuss the evidence in detail, but prima facie certain reasons has to be assigned in the order why the conviction has been suspended, so that it is not an empty formality. So if you found this video informative, don't forget to give it a thumbs up, share it with your friends, and leave your thoughts or questions in the comment sections below. And as always, I always request you to subscribe and hit the notification bell to stay updated on more intriguing legal topics. Thank you for tuning in, and we will soon see you in the next video. Until next time, stay curious, stay informed, and stay legal.